Malacanang says President Bongbong Marcos will look into the economic implications of the proposed measures seeking to increase minimum wage earners' salaries by 200 pesos per day. The House of Representatives earlier approved on third and final reading House Bill number 11376 or the proposed Wage Hike for Minimum Wage Workers Act. In a briefing on Thursday, June 5, Presidential Communications Office Undersecretary Claire Castro says the President wants to look into all aspects and concerns of all stakeholders.
Ito lamang po ang mensahe ng Pangulo, and I quote, "We will look at the economic implications of this and how to resolve this with the opinion of the wage boards, since the wage boards are also the creations of the Congress." So nais po ng Pangulo na maibigay kung ano po ang makakabuti sa mga manggagawang Pilipino. Titignan ng lahat ng aspeto at ang concerns ng lahat ng stakeholders.
The proposed measure was approved on Wednesday, June 4, after 172 lawmakers voted in the affirmative, none in the negative, and 1 abstention. The bill seeks to increase by 200 pesos per day the daily rate of all minimum wage workers in the private sector, regardless of employment status. Based on the bill, this covers workers in contractual and subcontractual arrangements, whether agricultural or non-agricultural. According to the final version of the bill, the regional tripartite wages and productivity boards can still implement wage increases even if the proposed measure is enacted. The bill warns that the wage hike must not lead to the reduction of existing allowances and benefits. Senate Minority Leader Koko Pimentel says the summary dismissal of the impeachment case against Vice President Sara Duterte will violate the 1987 Constitution. Senator Bato de la Rosa earlier initiated a draft Senate resolution seeking to declare the de facto dismissal of the impeachment case. According to Pimentel, the resolution should be brought before the Senate Impeachment Court. Pimentel says it is unconstitutional if the impeachment case is summarily dismissed because trial should forthwith proceed. He adds that the public has the right to know the evidence presented by their representatives against an impeached official. Pimentel says that the impeached official must also be given the opportunity to defend themselves. Senate President Cheese Escudero set the presentation of articles of impeachment on June 2, but he later moved it to June 11, the last day of session of the 19th Congress before adjourning sine die. Majority Leader Francis Tolentino warned that failure to finish the trial by the end of the 19th Congress on June 30 will deem the impeachment case functionally dismissed. He believes the Senate cannot carry unfinished proceedings into the next Congress. But Pimentel says there is no constitutional provision that expressly prohibits the 20th Congress from continuing the impeachment proceedings. Senate Majority Leader Francis Tolentino rejects the suggestion that he should inhibit himself from the impeachment trial of Vice President Sara Duterte for supposedly prejudging the case. In a radio interview on Thursday, June 5, Tolentino asks on what grounds should he inhibit himself from the case. Tolentino stresses he won't inhibit himself because he doesn't see a reason to do so. In an earlier interview, constitutionalist Christian Monsod said that Tolentino and Senator Bato de la Rosa should recuse themselves from the impeachment proceedings against Duterte. For Monsod, the two senators have already lost their independence with their attempts to stop the impeachment proceedings against Duterte. Tolentino refutes Monsod's remarks. The senator explains that he never judged the merits of the impeachment case when he argued that it could be considered functionally dismissed after the 19th Congress adjourns. Tolentino believes he only said what was right according to the Constitution. Meanwhile, De La Rosa owned up to a draft resolution urging the Senate to dismiss the impeachment case. The draft resolution cited the alleged failure of the Senate to immediately act on the articles of impeachment which were transmitted from the House of Representatives on February 5. The presentation of the articles of impeachment was originally scheduled for June 2. However, Senate President Cheese Escudero rescheduled it to June 11, the last day of session of the 19th Congress. According to Escudero, the Senate can only convene as an impeachment court after the presentation of the impeachment charges against Duterte. Faculty members of the University of the Philippines College of Law urged the Senate to start the impeachment trial of Vice President Sara Duterte. Individual members of the UP Law faculty released on Thursday, June 5, an open letter urgently calling on the Senate to forthwith proceed with impeachment trial. More than 100 members of the UP Law faculty signed the open letter as of Thursday afternoon. According to the letter, members of the UP Law faculty expressed grave concern over proposals to dismiss the impeachment case against Duterte. The UP Law faculty members believe the grounds cited in the draft resolutions are not supported by factual developments and a proper reading of the Constitution. The faculty members say they are concerned not because they necessarily believe in the charges, but because they want to see the evidence and hear the Vice President's defense. They believe the Senate's dismissal of the case without hearing a single witness will alter the system of checks and balances. The letter states that the dismissal will also undermine the public's trust in the Senate as an independent and impartial institution. Senator Bato de la Rosa earlier initiated a draft resolution seeking to dismiss the impeachment case against Duterte. His draft resolution states that the current Congress doesn't have enough time to deliberate the articles of impeachment. According to de la Rosa's document, the impeachment trial can't cross over to the incoming 20th Congress. Senate Majority Leader Francis Tolentino also said the impeachment case against Duterte will be functionally dismissed after the 19th Congress adjourns. Senate President Pro Tempore Jinggoy Estrada wants the mandatory senior high school level under the K-12 program removed from the country's education system. In his proposed Senate Bill number 3001, Estrada says a rationalized basic education program would better benefit learners. His proposed measure aims to amend Republic Act No. 10533, also known as Enhanced Basic Education Act of 2013. The bill proposes the retention of fundamental principles of the Enhanced Basic Education Act, but specifically seeks the removal of the mandatory SHS level. Estrada proposes a 1-year kindergarten education, followed by 6 years of elementary education and 4 years of secondary education. According to Estrada, the mandatory SHS level under the K-12 program has been met with criticisms and objections from various groups since it was put in place. He cites the burden of extra time and cost of senior high school that students and parents have to shoulder. He then points out that the SHS program was designed to bring the Philippine education system closer to international standards by serving as a bridge between high school and college, but he believes it still has not fully achieved its goal. Estrada cites the admission of Department of Education officials that the SHS program has not yet reached its vision for the K-12 graduates. He notes the congested curriculum, overworked teachers and students, and the low employment rate of SHS graduates. Estrada believes his proposed bill will be a step in fixing the country's basic education system.